Good day, everyone. My name is Russell John Maginang. I'm here to discuss to you the Chapter 3 Evidence in Crime. Before formally start in my topic, we have a learning outcomes. At the end of this topic, the students are expected have to recognize and understood the legal kinds of evidence that could guide police officer in their conduct of criminal investigation, identify the individual roles and value of presented evidence in crime, acquired the theoretical practice skills in connecting, marking, tagging, and preserving evidence, and applied a proper P&T procedure to processing piece of evidence in crime scene. Let's proceed to lesson 1, evidence. What is evidence? Evidence, it is legal definition. It means sanctioned by this rule of ascertaining in judicial proceedings the truth respect a matter of fact. It also refers to any materials which tend to persuade the court of truth or probability of some facts alleged to asserted before it. The object as a evidence, it is addressed or addressed in a sense of the court. It when the object is relevant, it is fact in issue. It may be exhibited to examine or to view by the court. In terms of evidence, it relates in investigation. It speaks to a wide or information sources that might eventually inform the court to prove a disapprove the points of trier of facts. The source of evidence is anything that observation or the witness of examination and analysis and the physical objects. There are three types of evidence. First, oral testimony. What is oral testimony? Oral testimony can be described as a oldest type of evidence. Before people started to write down otherwise record in their history, they pass informed by generation to generation through storytelling. Next is documentary. The real documentary as a evidence consists the writings of material containing letters, words, numbers, figures, symbols. Other method can be used in written expression. It offers as a proof to their content. The evidence include wills, lenses, memorandas, report, con- contacts, promissory notes, ransom notes, and other checks. Documentary evidence is the authenticated before is admissible. Next is the circumstantial evidence. Circumstantial evidence, it is in indirect evidence that does not its space prove a facts. It is give a drawing additional reasonable inferences in order to support the claim. For instances is uh, the evidence, the constantial evidence of intentional discrimination. It includes the suspicious timing, ambitious statement, indifferent treatment, and personal use and other evidence can allow a jury to reasonably infer the international discrimination, intentional discrimination rather. There are three forms of evidence in criminal investigation. First, physical evidence. Objects or optic and real evidence. It refers to the physical object used as evidence which is obtained through searches in scene of the crime. There are many examples. Firearm, fired ammunition, knife or bolo, blood, semen, saliva, human or animal, biological samples, finger and footprints, tool marks and tire tracks, hair, fiber, glass, paint, and other trace evidence. Physical evidence is a object or items that establish that crime has been committed, of established link between a crime. It is perspector or crime of its victim. It legally object evidence refers to evidence made known as address in a sense of a court. Next is category of physical evidence. Um, associative associative evidence. These are pieces of evidence which link a person to crime. It is a can be used to provide a links between a individuals and in, in individuals involved in the crime. Um, in some cases, it is the associative evidence is may sufficient to prove or to contact in other cases. The associative evidence may be less deductive or provide collaboration of other evidence. Next is trace evidence. These are evidence are consist investigator locating the suspect. The trace evidence is created when object make contact material and is obtained and transferred in heat induced in contact friction. Next is biological and transient evidence. Biological evidence is referred to evidence that is commonly recovered in crime scene. It biological evidence can be referred to biological material or substance such hair, tissues, bones, teeth, semen, and other body fluid. It include item containing biological material use a biological materials used to collaborate and provide means of proving statement claims in trial. Pres- preserving preserving biological evidence from crime scenes critically important because the DNA can be provide the evidence can be provide a best evidence to an innocence or guilt and upper review of the cases. Next is transient evidence. It refers to its nature can be easily changed or lost. It usually observed that the first officers at the crime scene, the pattern of evidence produced indirect by direct contains between the person and an object between two objects. It is mostly found in from imprints, indications, struction, markings, fractures, or deposits. For example, the transient evidence could be the odor, the or color change of the items, transfer of evidence, or also known as trace evidence, the type of evidence that could it is a result of physical contact between the objects and the persons. What is corpus delicti? In Latin word for body of the crime. Corpus delicti is the Latin phrase that means the body of crime. The phrase of the body here is not only to pertain the possible corpse, but actually relates on the form of evidence. It is important to remember that there are both literally a figurative association rather. It regards the criminal investigation. Its concept means it is that should enough in evidence to prove that a crime occurred in order to individual charged for his offense. Next is other specific physical evidence. Soil. Soil is the organic nature materials such as rock, minerals, and the decomposing plants. It may also contain man-made materials as brick, concrete, glass, or paint. Scientific technique to analyze a soil called the density gradient tube. So, soil can be provided important information to criminal investigation as a transfer evidence because it may many criminal cases takes place under circumstances such as to transfer a criminal victim and the ver- very um, variation of the soil from the place to place can make a soil valuable evidence to prove linkage between a suspect from a crime scene. The soil is a complex mixture which is verify a mineralogical and chemical, biological, and other physical properties considering the complexity and variety of the methods have been developed in forensic science purposes. It because of the materials are important to content a soil in mineralogical examination is essential in forensic soil and identification. Paint. It is the pigmented polymer or as applied adheres various surface. Paint is evidence occurs to transfer a variety of crimes, include the vehicular, hit and runs, assault, and burglaries. A type of paints evidence that could usually encountered. It includes automotive, architect, architectural, or the maintenance paints. Paints analysis can also include another coating and polymer. It named as gas chromatography. Next is the tool mark. Tool mark is the any mark that could created when a instrument has contact and other surface. Tool mark is a impression or scratch or abrasion made when a contact occurs between a tool or other objects. Tool marks can be linked by a tool used in the crime scene. It automatically can may be used to help and find suspect. Who is it? Next is shoe print impression. Shoe print are created when the materials from the bottom of the shoe transferred to another surface. Shoe impression are often left in soft material. Shoe print can be analyzed to determine suspect used to size and brand of the shoe, as well as a individual characteristics such as wear patterns, depending how to wear a wax or specific damage, nicks or cuts, and etc. Impression of the foot shoe print, like a dirty footprint on the floor, can be lifted used to techniques similar to fingerprint. Next is video evidence. Video evidence is the potential extreme power from evidence. The videotape is the recording some type of witness and testimony can be used as direct evidence to suspect as a claim. Next is a dental facts. A dental evidence is a facts of individuals' is unique set of teeth in term of the two a term of form, arrangement, and dental work of bite. Um, there are dental identification and birthmarks. It has in both instances the in facts that could be worked as a bite in marks. Dental evidence power form of criminal identification consists a um, distance of between the teeth or the shape of the mouth or bite, teeth alignment and teeth shape and teeth missing and wear patterns of the teeth. Next is the computer of other electronic evidence. Computer, cellular phones, and other personal digital assistants may provide a wealth information regarding the communication schedule of criminal behavior. Um, Therefore, they're potentially valuable source of evidence in criminal investigation. Examination of electronic hardware is the quite technical in nature, and both in proper informed to result in loss of evidence. Next is testimonial evidence. Is known as eyewitness testimony and the com- communicative evidence. It is a product of interrogation with a witness, smell, hear, taste, and touch are being described in oral written testimony. It refers to the person's testimony. It offers to prove or to prove a truth or a matter asserted, especially to evidence elected from a witness. It is oral or written assertion. It offers to a court as a proof of the truth that which being selected. Um, Kinds of testimonial evidence. Ordinary witness is the any person commission a crime testified before the court just be considered as a ordinary witness. Also, the physician could testify the court on matters is a perceived from a patient course to physician um, relationship that considers as a ordinary witness. A witness is testified only those facts that he knows his knowledge that what could be described a derived from the own perceptions known as otherwise providing in these rules. Next spec- is expert witness. The person does testimony concerning of the investigation that based in training and experience. A person, a physician who confirmed before in a court cause of death of the victim considered as a expert evidence. Next is who is a witness. A witness is the person to who the testified under the oath in trial in disposition of lawsuit. The plaintiff of defendant may be witnesses. The witnesses can has a first-hand knowledge about the matters relevant to the case and other testimony and subject of applicable rules of evidence. It is a legal definition that refers to a person who perceive a and perceiving can be there known as perception and other may be a witness. Next is what is this deposition? Deposition testimony is general under oath that court reporter can be deponent. Other signs of advits testing and accuracy of the subsequent printed transcript. Um, it is a disposition of testimony. It that can be taken oral or with the attorney asking a question and the deponent is the individual can being a question or answer while a court reporter recorder or some both record the testimony. Next is documentary evidence. Refers to the writings include the official record of content that could speak themselves and read from investigation and the court. It is it is a figure, symbols, and other modes or written expression offered to prove their content. It is documentary events. Evidence can be not limited to the following: the birth, death certificate, necropsy report, and medical examination.